you're watching Crypto Market News, and we got a chance to talk to Garcia. Joe, where in the world would you say the conditions regarding law for blockchain are the best?
Okay, well that's a good question. I mean, to give you a bit of oversight, so my background is obviously in sort of financial services, law and regulation, but I've worked with the government of Gibraltar to build out a specific legal and regulatory framework for groups that use distributed ledger technology for the transfer or storage of value. And it's been pretty well reported, and some of the largest groups in the world have pursued that license opportunity. And I think that's really driven by groups that looking for what we call sort of regulatory certainty around the operations. People want to be clear on how they need to be operated, regulated. And also, I think the really key issue with all the jurisdictions that are looking at this is that the regime is actually proportionate to the actual business, right? So in lots of countries, I think people have tried to form arguments that certain operators or users of blockchain technology are caught within existing frameworks, the classic sort of securities argument from a US perspective. In Europe, you have some regulators that look at collective investment scheme rules, some regulators try and move everything into the payment services universe. So we've taken a slightly different view. We looked at the famous bit license operations in New York and other places like that, and we built out a sort of ground-up, proportionate, principles-based regime specifically for operators or groups that use distributed ledger technology for the transfer or storage of value. So I mean, if you say to me, what are the best places in the world? I mean, I would say, this was the first legal regime that was built out specifically for the sector. So I think Gibraltar is on most people's roadmap at the moment, so I think I would have us right up there. I suppose that's a natural comment for me to make there.
There is no common regulatory system on ICOs and cryptocurrencies in the EU and other countries. So how this system should be carried out in your opinion?
From the European Union perspective, the regulation has, I think, historically been focused very much on the sort of AML, KYC side of things. AMLD5, the new anti-money laundering directive, will capture custody wallet providers and exchanges, but I mean, it's a difficult position for a lot of those countries to be in. The approach of some countries they've taken, like Gibraltar, is to try to capture any form of, call it, utility token that falls outside of the definition of something like a transferable security within a new type of token definition, and to build out specific regimes for that. So the way we're approaching it is a whole new set of law and regulation that introduces a requirement for an authorized and regulated sponsor to support the launch of a particular token. That's what we're planning to do moving forward. And I think that the natural direction for me that should be followed is for new regimes to be built out. The problem that we find, I think, is that sometimes even at a European level, things like crowdfunding regimes have taken something like 8 or 9 years to try to be agreed at an EU level, and that's very difficult. So that is why some of the smaller jurisdictions are able to sort of formulate their own policies and regulation and law and to move that quickly. But I mean, people like us, people like Gibraltar, I think the key thing is that you're right. Some crypto-related business or ICO activity might fall outside of the scope of regulation. That is risky, so we want to bring it within the right form of regulation.
On one hand, blockchain is immutable, and on the other hand, GDPR allows to erase, add, or delete existing information. GDPR is more suited for centralized system rather than already existing decentralized like blockchain. So what are their contradictions? Does GDPR block the blockchain, or can those two systems coexist?
GDPR was not built with blockchain in mind. It's years of development. None of the planning around GDPR was built around the concept of an immutable ledger of data or information. So, I mean, the answer to your question is that people are approaching, so, a data subject's right to have that information not stored in an immutable public ledger is very, very obvious, especially under GDPR. I think the way that people are approaching this is always slightly different. So some people are constructing almost sidechain mechanisms. So there are mechanisms that actually store the actual data, which is just reflected on the actual blockchain, and the blockchain contains a sort of reference across to the actual data. So it's almost a sort of a record of the information existing, but not the actual data contained on the blockchain itself. So that is one of the approaches that some groups are taking. Others there are lots of different approaches, but very clearly what is not compatible is the idea of someone's identity data to be stored on an immutable ledger which has touch points to various other things. That will not work from a GDPR perspective. Lots of law firms and groups and countries are looking at different ways of approaching this, dealing with their own regulatory authorities in terms of that specific question, and there isn't a short answer. But at a high level, it's not compatible, but at the same time, there are potential solutions. So that's a very short answer to that question.
You've written a chapter of the recent Global Legal Insights publication on blockchain and crypto regulation in 2019. So what is that?
It's a complex area, and some people are trying to, centralize data on how different jurisdictions are approaching it. So that's one example. There's a Wharton RegTech initiative that brings regulators from around the world. Again, the idea is to try and bring people together to share concepts and ideas of how different jurisdictions are approaching these questions. Even under European law, sometimes the interpretation of what triggers the definition of a transferable security, what triggers the definition of electronic money, what triggers the definition of all sorts of things is subject to interpretation. So the idea with initiatives like that, I think, are firstly to cover the key topics of the space, and then to get a jurisdictional kind of breakdown of how each country is approaching it. And obviously we contribute to those things because there's an interest in how Gibraltar has formed its view and how it's approaching that. So that's really the rationale behind that.
All right, thank you so much for your time, Joey. It's been a pleasure.